In 1919, the British government passed the Rowlatt Act. This legislation handed colonial authorities the power to suppress political opposition through indefinite detention and warrantless arrests. Millions of Indians responded in mass campaigns of nonviolent civil disobedience. They demanded strict limits on government power and guaranteed civil freedoms. As the British withdrew, the priority shifted to creating a supreme set of laws that would ensure the new Indian government remained legally bound to respect the freedoms its citizens had just won. The Indian Constitution was drafted out of a distinct fear of unchecked state power. It was engineered to serve as a permanent legal barrier between the citizen and the potential for tyranny. To build this barrier, the nation elected a massive, highly diverse body known as the Constituent Assembly. Hundreds of representatives from varying political, religious, and ethnic backgrounds gathered to debate the future framework of the country. The responsibility as taking those sprawling debates and structuring them into a coherent legal document fell to the drafting committee, chaired by Dr. B.R. Ambedkar. As the chief architect, he guided the precise language that would govern the republic. This diagram breaks down the document adopted on November 26, 1949. It contained exactly 395 articles, divided into 22 parts and 8 schedules. That structural volume makes it the longest written constitution in the world. It needed that space because it actively outlawed deeply entrenched pre-independent social practices, specifically abolishing untouchability and forced labor. The drafters delivered a heavily engineered socio-economic blueprint, attempting to rebuild Indian society from the ground up through sheer legislative force. The core of this blueprint is divided into 2 distinct sections. Part 3 contains fundamental rights. These are individual liberties, like the right to equality and personal life, that are fully justiciable. If they are violated, a citizen can demand enforcement directly in a court of law. Part 4 outlines the directive principles of state policy. These are broad socio-economic goals, like protecting the environment or securing a living wage, that the government is expected to pursue. However, unlike fundamental rights, they lack legal teeth. You cannot sue the government to achieve them. To manage these rights across a vast nation, the drafters included Article 35. This provision gives Parliament exclusive authority to pass laws enforcing these rights uniformly across all states. The Constitution operates on this exact tension. It arms the citizen with a legal sword to defend their liberties, while handing the government a policy compass to guide the nation's economic development. We can see how this tension works by looking at the right to education. In 1950, education was placed under Article 45 as a directive principle. The state had a moral obligation to try and provide free schooling, but no child could legally compel the government to build a classroom. That boundary held for decades. Then, in the 1993 Unni Krishnan case, the Supreme Court ruled that the ability to enforce any right relies on a person's education. Therefore, they declared the right to education inherently flows from Article 21, the right to life. The legislature responded in 2002 with the 86th Amendment. This inserted Article 21A, upgrading free and compulsory education for children aged 6 to 14 into an enforceable fundamental right. By moving a policy goal into a guaranteed civil right, the Indian state demonstrated the flexibility of its founding document. The text can update its own mechanisms to meet the evolving demands of its citizens. That flexibility also carries immense risk. Between 1975 and 1977, Prime Minister Indira Gandhi declared a state of emergency. During this period, elections were delayed, the press was censored, and basic civil liberties were suspended. In the middle of this emergency, her government passed the 42nd Amendment Act of 1976. The legislation altered 59 different sections of the text, drastically shifting the national balance of power. It was so massive in scope that it is widely known as the Mini-Constitution. This is the original text of the 1949 preamble. The 42nd Amendment permanently inserted 3 new words into this opening statement, redefining India as a socialist and secular republic, and prioritizing the integrity of the nation. Beyond the preamble, the amendment transferred 5 major subjects, including education and forests, from state jurisdictions directly to the concurrent list, giving the Parliament greater control. Simultaneously, it restricted the power of the Supreme Court and High Courts to review and invalidate central laws. The 1976 amendment revealed a critical vulnerability. A determined parliament with enough votes could use the Constitution's own internal amendment process to rewrite the core identity of the republic. The ultimate check against this kind of legislative dominance actually came a few years prior, in the landmark Kesavananda Bharati Supreme Court case. The court established the basic structure doctrine. This ruling stated that while Parliament holds the power to amend the Constitution, it absolutely cannot destroy its foundational principles. Core tenets like democracy, secularism, and judicial review are permanently shielded from being voted out of existence. Because of this ruling, the modern Indian state operates in a continuous state of tension. The Parliament attempts to adapt the laws to modern political needs, while the judiciary stands guard over the original foundation. Ultimately, the Constitution serves as the final barrier against absolute authority. Through its evolving rights and the shield of its basic structure, the document ensures that even as the state changes, the fundamental protections of the citizen remain intact.